I ask consent to call the quorum be dispensed with.
Without objection.
Madam President, for the sake of my colleagues, I want to talk about the time of the hearing of the Sotomayor, Judge Sotomayor nomination. I talked with the distinguished ranking member last week on this schedule, and I would note the concerns he had raised. But I'm announcing today that the Senate Judiciary Committee will hold the confirmation hearing on the nomination of Judge Sonia Sotomayor to be an Associate Justice of the United States Supreme Court on July 13th. This is a reasonable schedule. It'll be the middle of next month. It's in line with past experience. It's going to allow several more weeks for committee members to prepare for the hearing, several more weeks than if I'd held the hearing this month. And there's no reason to unduly delay consideration of this well-qualified nominee. And she deserves the opportunity to go before the public and speak of her record, especially if some have mischaracterized her record, has misstated her record. The only place she can speak, I would say, Madam President, the only place she can speak and speak of her record is in a hearing. But it's also a reasonable schedule that serves the many interests involved. Of course, the first and foremost is the American people's stake in a process that's fair and thorough, but not needlessly prolonged. It serves the purpose of the institution of the United States Senate, where we need sufficient time to prepare for confirmation hearing. And we have a full legislative plate of additional pressing business in the weeks and months ahead. It's of great importance to our constituents and to the nation. And then, of course, it serves the needs of the third branch of government, which depends on the other branches of government to fill court vacancies in our independent judiciary, and the needs of the President, who has nominated Judge Sotomayor. But lest we forget, serves the needs of the nominee herself, who is a judge, will only be able to speak publicly about her record when the hearings are convened. Madam President, this is an extremely important obligation that we as members of the Senate take on. There are only 101 people who get a direct say in the nomination and confirmation of a United States, of a justice of the United States Supreme Court. First and foremost, of course, the President of the United States, and in this case, President Obama, consulted with numerous senators, Republicans and Democrats alike, prior to making his nomination. And then once a nomination is made, the 100 members of the United States Senate have to stand in for 300 million Americans in deciding who will get that lifetime appointment. I voted on every single member of the United States Senate currently, as well as some in the past. And I know how important an obligation that is. The justice who takes Justice Souter's place for the court session that convenes October 5 also needs as much time as possible to hire law clerks, set up an office, even a place to live here in Washington, and take part with the rest of the court in the preparatory work that precedes the formal start of the session on the first Monday in October. Now, I mention that, Madam President, because I have put together a schedule that tracks the process the Senate followed by bipartisan agreement in considering President Bush's nomination of John Roberts to the Supreme Court in 2005. At that time, I served as the ranking minority member of the Judiciary Committee. I met with our Republican chairman. We worked out a schedule that provided for Chief Justice Roberts' hearing 48 days after he was named by President Bush. I might say that that agreement on time was reached even before the committee received the answers to the bipartisan questionnaire. And while Justice Roberts had not, then Judge Roberts had not decided as many opinions as Judge Sotomayor, he had been in a political policy position in Republican administrations for years before, and there were 75,000 pages of documents. In fact, some arrived almost on the eve of the hearing itself. And of course, that nomination was to replace Justice O'Connor, who was recognized as the pivotal vote on the Supreme Court. Now, if something that significant required 48 days, and Republicans and Democrats agreed were sufficient to prepare for that hearing, in accordance with our agreement in the initial schedule, certainly that is a precedent that says we have more than adequate time to prepare for the confirmation hearing for Judge Sotomayor. And in selecting the date, I'm trying to be fair to all concerned. I want to be fair to the nominee, allow her the earliest possible opportunity to respond to attacks made about her character. It's not fair for her critics to be calling her racist when even equating her with the head of the Ku Klux Klan. An outrageous comment, outrageous. Both Republicans and Democrats have said outrageous. All who know her know how outrageous it is, but she can't speak to it until she's in the hearing. In 2005, when President Bush made his first nomination to the Supreme Court, Senator McConnell, who was in the majority whip, asserted that the Senate should consider and confirm the nominations within 60 to 70 days. We worked hard to achieve that. The nomination of Judge Sotomayor should more easily be considered within that time frame. We were still able to complete Senate consideration, and the Senate confirmed John Roberts to be the Chief Justice of the United States 72 days after he was initially designated to be an Associate Justice. We did this despite the fact his initial nomination was withdrawn, and only shortly before his hearing, he was renominated to serve as the Chief Justice of the United States. And we did this despite the terrible aftermath of Hurricane Katrina, where everybody, Republicans and Democrats alike, agreed that we should hold back a week on the hearings so that we could all concentrate the nation's resources on Hurricane Katrina. And so that required a week's delay. And then 72 days after, if we followed the same schedule, 72 days after Judge Sotomayor was designated to the Supreme Court, it would be August 6th, and we're not even having the week of Katrina. Now, the hearing is the opportunity for all senators on the Judiciary Committee, both Republicans and Democrats, to ask questions, raise concerns, evaluate the nominee. Our Republican colleagues said they intend to ask her about her judicial philosophy. Now, it doesn't take 4 months to prepare to ask these questions. In fact, most of them have already raised the questions. They'll surely be prepared to ask them more than a month from now. And during that month, we have a week's vacation from the Senate. Now, I intend to be using that week without the interruption of committee hearings, without the interruption of votes, without the interruption of regular Senate business, to prepare for the hearings. I would advise those senators who feel they have to have extra time, forego your vacation. Spend that week preparing for the hearing. Because this is an historic nomination. This is an historic nomination. And I hope all senators will cooperate. It's a schedule that I think is both fair and adequate. Fair to the nominee, but also adequate to the United States Senate to prepare for the hearing and Senate consideration. There's no reason to indulge in needless and unreasonable delay. And I say that it's an historic nomination, Madam President, because it should unite and not divide the American people in the Senate. Hers is a distinctly American story. Whether you're from the South Bronx or the South Side of Chicago or South Burlington, Vermont. The American dream inspires all of us. Her life story is the American dream. And so, I might add, is the journey of the president who nominated her. She deserves a fair hearing, not trial by attack and assaults upon her character. And let us proceed to give her that fair hearing without unnecessary delay. I have said over my 35 years here in the Senate, oftentimes on the floor of this great body, that we senators should be the conscience of the nation. That's what we're called upon to do. And there have been occasions when this Senate, Republicans and Democrats alike united, have shown they can be the conscience of the nation. I would say this is one time we should rise above partisanship and be that conscience. When I met with Judge Sotomayor last week, I asked her about her approach to the law. She answered that, of course, one's life experience shapes who you are. But ultimately and completely, her words, as a judge, you follow the law. There's not one law for one race or another. There's not one law for one color or another. There's not one law for rich and a different one for poor. There's not one law for those who belong to one political party or the other. There's one law for all Americans. And she made it very emphatic. As a judge, you follow that one law. There is only one law. We all know that. She said ultimately and completely a judge has to follow the law no matter what their upbringing has been. That is the kind of fair and impartial judging that the American people expect. That is respect for the rule of law. That is the kind of judge she has been. Judge Sotomayor is extraordinarily well equipped to serve on the nation's highest court. To borrow the phrase that the First Lady used last week, not only do I believe that Judge Sotomayor is prepared to serve all Americans on the Supreme Court, I believe the country is more than ready to see this accomplished Hispanic woman do just that. This is an historic nomination, and it's an occasion for the Senate and our great nation to come together. This is a time for us to come together. The process is another step toward the American people regaining confidence in their judiciary. Our independent judiciary is considered to be the envy of the world. Though less visible than the other two branches, the judiciary is a vital part of the infrastructure that knits our nation together under the rule of law. Every time I walk up the steps into the Supreme Court, I look at the words engraved in marble from my native state of Vermont. So over the entrance of the Supreme Court, those words say equal justice under law. The nomination of Judge Sotomayor keeps faith with that model. President Obama is to be commended for having consulted with senators from both sides of the aisle. I was with him on some of the occasions he did. I've had senators come up to me, Republican senators, and tell me they had never been called by a president of their own party, say nothing about a Democratic president, to talk about a Supreme Court nominee, but President Obama did call and reach out. But now the Senate's duty comes to the fore. And I hope all senators, both parties, will work with me to move forward, to consider this nomination in a fair and timely manner. Madam President, I yield the floor and suggest the absence of quorum.
Clerk will call the roll.
Mr. Akaka.